So this is a miscellaneous petition against
Yes.
the order of the trial court. Sir, what has happened?
What is the order?
So the order is that they rejected my application of order 617 partly. That order is on page number 15, annexure A1.
Order 6 rule 17. You are plaintiff or defendant?
Sir, I'm defendant.
Defendant.
Yes, sir.
So what is the stage?
Sir, the trial is at the state of chief examination
Of whom?
of plaintiff.
Plaintiff.
Yes, sir.
Show me from the order sheet.
Yes, sir. Sir, it is on page number 50.
50.
Yes, sir.
Yes.
Sir, I am reading out from para number 2.
Yes.
प्रतिवादी द्वारा आवेदन के माध्यम से जवाब दावे की कंडिका 10-11 को विलोपित कर उसके स्थान पर नवीन कंडिका क्रमांक 10-11 के विषय में वर्णित तथ्यों को समाहित करने का निवेदन किया गया है, जिस संबंध में वादी अधिवक्ता द्वारा घोर आपत्ति की जाकर व्यक्त किया है कि जवाब दावे में उपरोक्त कंडिका की प्रकृति स्वीकारोक्ति है, जिन्हें विलोपित की जाने की अनुमति प्रदान नहीं की जा सकती। उपरोक्त तर्क के समर्थन में सो एंड सो जजमेंट वाज गिवन। जवाब दावे कंडिका क्रमांक 10 एवं 11 में प्रतिवादी द्वारा यह स्पष्ट रूप से स्वीकार किया गया है कि वादी ने उसके अधिवक्ता के माध्यम से प्रतिवादी को सूचना पत्र प्रेषित किया था तथा यह भी उल्लेख किया है कि वादी द्वारा प्रेषित सूचना पत्र का जवाब प्रतिवादी द्वारा प्रेषित किया जा चुका है। उपरोक्त कंडिकाएं स्वीकारोक्ति प्रकृति की है, जिन्हें निश्चित ही विलोपित किए जाने की अनुमति प्रदान नहीं की जा सकती। इस संबंध में वादी द्वारा प्रस्तुत न्यायाधीशान भी अवलोकनीय है। इसके अतिरिक्त प्रतिवादी द्वारा इस तथ्य का भी कोई युक्ति कारण दर्शित नहीं किया गया है कि उपरोक्त संशोधन विचारण प्रारंभ होने से पूर्व क्यों नहीं किया जा सका। Now, sir, the trial court rejected my application on 2 grounds. That I admitted that I received the notice of the plaintiff, and since this admission I am trying to alter, so it can't be allowed. This was the first ground. And the second was that I have not given any reason that why I have not done the said amendment prior to the start of the trial. So answering the first question, sir, I'm relying on a judgment.
Recently, day before yesterday, I decided that admission 670 cannot be withdrawn. In the admission already gathered.
Sir, the lordship, please.
Day before yesterday, वो उनका था claim petition में था. He was the driver, and then he said that now in the written statement earlier he said that he is not driver. Then he wanted to say that no, he is driver. So पेमेंट नहीं किया.
Sir, if the court may please appreciate this judgment.
Have you seen Justice Parthiwala's judgment on 617 regarding the admission if you have made in the plaint or the written statement cannot be withdrawn by filing 617?
Sir, I'm clearing that point.
Have you seen that?
No, sir, I have not
This
seen
is
that.
recent. I've just decided day before yesterday.
Sir, I'll try to cope up with that. Sir, if the lordship may bear with me. Sir, here this judgment is of Kerala High Court. Sir, B.K. Narayan Pillai versus Parmeshwaran Pillai.
This is Kerala.
Yes, sir.
Are you
No, sir, it is
Madhya
episode-
Pradesh Supreme Court?
I'm just pointing out few points only.
Huh.
Sir, I'm reading out from paragraph number 9. The principle of the amendments of the plaint are equally applicable to the amendments of the written statement. The court are more generous in allowing the amendment of the written statement as question of prejudice is less likely to operate in that event. Now, sir, from last 7th line of the same para, proposed amendment should not cause such prejudice to the other side of the party which cannot be compensated by cost, and no amendment should be allowed which amounts to or relates in defeating legal right. Now, sir, this judgment clear that when an amendment can be allowed, sir, if it does not cause any prejudice and if it does not defeat any legal right. Sir, I am denying that I have not received the notice. Sir, the receiving of the notice or the sending of the notice, it is a procedural part of a eviction suit. It is not a legal right. And if I deny, my denial or my acceptance does not cause any prejudice to the plaintiff, because, sir, the trial court, he has to, the burden of proof ultimately lies on the plaintiff only because he has to prove that he served the notice. He will bring on record the postal receipt and all. So, sir, this is not causing any prejudice. It can be allowed on the cost. And the trial court taken a very hyper-technical view. Sir, I am also relying on one more judgment, answering the second question. The second question was that why I have not given any reason that why you have not done the said amendment prior to the start of the trial. So for that, I am reciting on the judgment of Honorable Apex Court of Dinesh Goyal. So this is the judgment 2020-24. So on para number 10, line number 5, the approach adopted by the civil court was termed hyper-technical, observing that in order to do complete justice, the application should have been allowed specifically when the cross-examination of the plaintiff had not begun. So in my case, I am the respondent. Neither the cross nor the chief or the respondent took place, nor the cross or the plaintiff took place. Only the chief examination of the plaintiff has taken place. And it is my admission or my denial of getting the notice. It is not causing any prejudice to the plaintiff. This amendment can be allowed on cross, sir. So this is my only submission.
Okay. The present petition has been filed by the petitioner, being accused by the order dated 21/8/2025, passed by 20th Civil Judge, Junior Division, Jabalpur, whereby an application submitted under Order 6217 CPC for incorporating amendment in the written statement has been discussed. Where it has been contended by learned counsel for the petitioner that the proposed amendment is not going to cause prejudice to either of the party, and therefore, as per the dictum of the Honorable Appeals Court, it should be allowed. It is further submitted that the principle of amendment is settled by the eternal judgments of the Honorable Appeals Court and the other High Court, by which it has been held that the civil court should not take hypothetical views in allowing the application, more so in the written statement. It is further submitted that if the proposed amendment is not causing prejudice to other side and that can be compensated by court, it should be allowed. And only in the cases where the legal rights are going to be defeated by the amendment, then it should not be allowed. Full stop. In the present case at hand, the application has been dismissed on the ground that, on the two grounds, that the amendment which has been sought is the nature of withdrawal of the admission which has been made in the written statement. Secondly, when the trial has already begun, it cannot be said that it was not in the knowledge of the petitioner defendant when the written statement was filed. Therefore, such view is a hypothetical view, and as per the law laid down by it should not be accepted and prayed for rejection of the cashment of the impugned order. Third, learned counsel for the petitioner peruse the record. It is evident from the impugned order that the court below has bestowed its consideration over the pleadings which has been tried to be incorporated by way of amendment. It has been observed by the court that once the admission in respect of notice, in respect of service of the notice has been made by the petitioner in the written statement, same cannot be withdrawn by way of filing application of the amendment. Such factual aspect is not subsequent in the nature, and same cannot be said that it was not in the knowledge of the petitioner at the time when the written statement was filed. The Honorable Apex Court, in the case of
Receive 20 rupees on Google
Life
Pay for
Insurance Corporation
Business.
India versus Sanjeev Builders Private Limited, another reported of the petitioner at the time when the written statement was filed. The Honorable Apex Court, in the case of Life Insurance Corporation India versus Sanjeev Builders Private Limited, another reported in 2022-16 SCC 1, has held that amendment can be allowed only when no injustice is going to be caused to either of the party, or the proposed amendment is not sought to withdraw any clear admission made by the parties. The present petitioner, the case of the petitioner falls within the second category, wherein the petitioner is trying to withdraw the pleadings and the admission which has been made in the written statement. The amendment which has been sought cannot be said